Thank you, Senator Brown. Senator Ludlam.
Thank you, Mr Acting Deputy President. I would like to add a couple of comments on behalf of the Australian Greens, in which I substantially agree with Senator Brown's comments. And I want to acknowledge the former Labor government, both for initiating Australia's signing the Marrakesh Treaty, but also for bumping a reference off back in 2012, I think, to the Australian Law Reform Commission that actually set the wheels in motion for some of the changes, the very welcome changes that we see today. And on that note, I'd also like to acknowledge Senator Fifield's office and Senator Fifield himself for bringing this bill to us today. I'll have a couple of comments towards the end of my contribution on the irony, I guess, maybe from a slightly different perspective to that Senator Brown took, of the fact that we're having to deal with this in non-contro. But let's start with what the bill does. Copyright, I suppose, is always going to be a balance between the protection of the rights of people who create works of art or literature or intellect to be fairly paid and to be acknowledged fairly for their work, and on the other hand, that there should be some common sense public interest limits to those rights. And nobody's suggesting that that balance is easy, but these are the sort of issues that we're grappling with here, that the government's brought to us in this bill. These issues have obviously been brought into very sharp relief in the digital age, where it's not just the volume of creation of work that's exploded, but the speed of distribution that has basically completely overrun the rather brittle system of checks and balances, some of which date back more than 100 years. And in this case, we're amending a bill that was written in 1968. Now, back in 1968, the internet was confined to a few hundred devices in the hands of US research institutions and military agencies. So if we roll the tape forward, it's very apparent thousands and thousands of hours of footage are loaded up to YouTube every hour, and the tools of creation and editing and recombination have now been substantially democratised. It used to be that you needed to own a printing press or a video editing studio to be able to create content. And now, of course, you carry around a printing press, a recording studio, a global research library and a distribution platform that can reach an audience of up to 3 billion people every time you pick up your mobile phone. And that is what has substantially overrun the old distribution bottlenecks that present copyright laws were designed to protect. The distribution bottlenecks of the 20th century, of the 19th and 20th century, aren't simply being eroded, they're being obliterated. And amidst this free-for-all, we in the Australian Greens are absolutely and emphatically not in the business of saying that artists now have to work for nothing just because it's so easy to copy stuff. The costs of copying have fallen effectively to zero now that many people are carrying these devices around. I've got an arts background, and I push back very strongly on the argument that just because your output can't be measured in tonnes, you should therefore be happy to see your creative output ripped off and shared without your consent. The point of balance here, obviously, is that we are also profoundly sick of the copyright industrial complex and their desperate calls on governments to maintain these 20th century distribution bottlenecks and their incumbency through occasionally recommending breathtakingly punitive acts of Parliament. If you're a big Hollywood studio, the idea that you can phase a cinematic release, just to give one example, through different markets, months and months apart, and then string it out through release on DVD, and then wring out a few more bucks out of the property on scheduled television, those days are done. You simply cannot do that anymore. There is this thing called the internet that makes that kind of marketing rollout distribution strategy completely obsolete. The internet interprets these obsolete strategies as points of failure. Game of Thrones, obviously, is the example that is used ad nauseum. Australia, being argued, I don't know if this is correct or not, but it's frequently argued as the world's biggest illegal downloader of that particular media property. Now, Game of Thrones costs millions of dollars to create. It employs thousands of people around the world, and they have a legitimate right to get paid, same as anybody else undertaking creative output. But of course, the significant central single reason why Australians were torrenting that series at such phenomenal rates is that you had to get a really expensive Foxtel subscription and take on thousands of channels of trash that or how many they're up to these days, that you're not interested in watching, just to watch that one thing at the same time as other people. And as distribution is democratised and brought into the 21st century, people are happy to pay. They're happy to pay, and they're also happy to pay for curation of material as long as it's affordable and reasonably easy to get a hold of. That's the 21st century distribution model, and that's where we'll see those rates of piracy falling through the floor as the distribution is brought up to date. Create the distribution channels and people will pay. So these and other issues is what the ALRC was wrestling with between 2012 and 2014. We've also had the IT pricing inquiry. I want to acknowledge our colleague over in the other place, Mr Ed Husick, who led the charge on that so-called Australia tax, which is basically media conglomerates and distribution incumbents charging Australians more for stuff because they can. And then they get Australian parliaments to pass laws to prevent people from circumventing that Australia tax. Yeah, there are other and more sensible ways around issues like this. We've seen bills on online infringement. We've seen effectively an internet filter brought in on the basis, or blocking legislation brought in on the basis of lobbying by the copyright industry to knock file sharing sites offline. And most recently, of course, we had the Productivity Commission, which reported in December 2016. This brings us to the issues in the bill, I guess, that maybe would have been controversial. Senator Brown alluded to them at the end of her contribution. I would argue, I suppose, and maybe I'm alone in this, that these things could have been brought in non-contro time because the Productivity Commission and the ALRC both recommended a fair use regime and a regime of safe harbours to protect those other than carriage service providers. And I'll just read a little bit from one of my favourite set of advocates on issues such as this, the Australian Digital Alliance, who should be congratulated today for helping the government steer these reforms through the parliament. They pointed out on safe harbours that the proposed changes, which were then knocked out of the final form of the bill that we're dealing with today, fixes what we believe to be a long-running error in how Australia implemented the Australia-US Free Trade Agreement, AUSFTA. The error restricted the application of the safe harbour provisions in the Australian Copyright Act to commercial ISPs, carriage service providers. And that's in direct contrast to the approach taken in other countries that ratified an FTA with the US government, which includes the safe harbour language, and that includes the US, Japan, Chile, South Korea and Singapore. So what you're doing there is disadvantaging and knocking out universities, schools, libraries and other user services, including aggregators like Facebook and YouTube. So that's gone, that's not here, and neither is fair use. A fair use regime which has been adopted, or a recommendation I should say, on basically anybody credible and independent of particular commercial interests, who's taken the time to look at this issue. Again, from the ADA, key recommendation is that Australia adopt a fair use exemption to copyright. Fair use is a defence to copyright infringement that effectively or essentially asks of any particular use, is this fair? In deciding whether a particular use of copyright material is fair, a number of principles of fairness factors must be considered. I beg your pardon, that was a quote from the Productivity Commission. Now, I would have thought that we could have seen those two important measures that have been subject to really widespread, pretty fine-grained review have been brought into this debate today. Unfortunately, it was not to be, and obviously that's something for a future government, either a coalition or a Labor government perhaps, that might consider that the weight of evidence stands very strongly on the side of passing these significant reforms to copyright law. But I don't want to take away, I guess, today is the day for advocates like Vision Australia and others that others have mentioned in the course of this debate, bringing Australian law into line with our obligations under the Marrakesh Treaty. Just to put this into plain English, under present law, if you use a text-to-speech reader to take a book or work of literature to make it available to somebody with a vision impairment, you're breaking copyright law. And that's ridiculous. And that's one of the things that we're fixing today. These are a really common sense set of reforms that